and do introduction.
Okay.
Louisiana Auctioneers Licensing Board. Today's date is September 17th, 2012. We are now on record.
Okay, this is docket number 12-0005, Louisiana Auctioneers Licensing Board versus Robert Burns. And the attorney's making appearance for the record.
Larry Bankston on behalf of the Louisiana Auctioneer Licensing Board.
Warren Kleinfeld representing Robert Burns.
Okay. Mr. Kleinfeld, I believe you have some motions.
Yes, sir. I've given you the motion to strike allegations of consideration / prematurity and the motion to recuse. Which one would you like to address first?
Let's go with the recusal.
Okay. The motion to recuse attaches the affidavit of Mr. Burns, and it asks that Ms. Steinkamp be recused. I understand she's voluntarily recusing as an employer being associated with the complainant. Okay. And it also asks that Mr. Bordelon be recused from hearing this matter, in that it can be demonstrated that Mr. Bordelon would not be fair and impartial in this hearing for Mr. Burns based on statements that have been made in prior board meetings.
Okay. With respect to Ms. Steinkamp, did you want to withdraw that motion since she's voluntarily recused herself?
Well, I mean, I think the record reflects that she is recusing herself, so
okay.
Certainly it's moot.
Okay. With respect to Mr. Bordelon, the reasons again or prior statements, you feel taking a position that would prevent him from being impartial?
Yes, sir. The statement particularly that my client be restrained by injunction from attending meetings of this board previously, based on the fact that he had litigation ongoing with the board.
Did you want to provide any witness testimony?
I would like to examine Mr. Bordelon on this statement, see if he admits to taking them.
Mr. Bankston, did you have any objection to having this?
No objections to me asking questions. I think the motion says, stated in open meetings, that the board should seek a restraining order prohibiting the mover from attending the meetings of the board. So that was the allegation in the motion.
Mr. Bordelon, can you swear on Mr. Bordelon, please?
Yes, Mr. Bordelon. Can you come sit over here where I can see? And also have you on the video that way. Thank you. If you'll stand right there and raise your right hand, do you solemnly swear the testimony about to give in this matter will be the truth and nothing but the truth, so help you God?
I do.
Thank you. Please have a seat right there. Mr. Videographer, is that good? Okay. Please go ahead.
Okay, Mr. Bankston.
Mr. Bordelon, would you state your name and residence address for the record, please?
Gregory L. Bordelon, Lake Arthur, Louisiana.
And you are a consumer appointee or member of this board?
That is correct.
And you intend, if not recused, to sit on this board in its consideration of the action to suspend, revoke, or otherwise take action against Mr. Burns? Is that correct?
Do I want to recuse myself? Is that the question? I didn't understand.
Well, my question was, do you intend to sit on this panel?
Yes.
Okay. So you do not want to recuse yourself?
No.
Roughly how long have you been sitting on this board, sir?
I'm going to say probably at least 5 years.
Isn't it true, Mr. Bordelon, that at a prior meeting, you on the record stated that you thought the board should seek injunctive relief to restrain and prohibit Mr. Burns from attending meetings of this board?
No.
You've never said that?
Well, to my knowledge, I
Okay. Is it, have you, to your knowledge, ever thrown out as a question to the board whether y'all could seek injunctive relief to enjoin someone from attending your meetings that has litigation ongoing with the board?
did. Yes.
And did that refer to Mr. Burns?
Yes.
So you do recall back in the summer of 2011 suggesting to the board that it seek injunctive relief prohibiting Mr. Burns from even appearing at subsequent board meetings, is that correct?
I think, no, that is not correct. I think my question was, if somebody's got a lawsuit against this board, should we not have that person in it before the court goes to case, is what I brought up.
And that referred strictly to Mr. Burns, correct?
Correct.
So my question again was, it was your statement that you wanted the board to consider enjoining Mr. Burns from appearing at board meetings?
If I remember right, it was just a question to our attorney if we could speak about anything in front of Mr. Burns since he had a lawsuit against the board. It was more a question, it wasn't a statement.
Well, it was your question and you used the word restraining and injunction and enjoining, did you not?
I don't think so. I don't remember that.
I've got a copy of it I can play for you.
Well, you can play it for me if I just don't remember at this minute. I don't remember using those words.
Injunction or enjoining or restraining, you don't remember that?
I don't remember using those words.
But that was the intent of your words? That you
Well,
wanted-
I just didn't think
Let
we
me-
should discuss it.
We're making her job very difficult.
Okay.
We talk on top of one another. It was your intent to question whether the board could enjoin or restrain Mr. Burns from
Correct.
attending meetings.
Correct.
In light of the fact that you wanted to exclude Mr. Burns from meetings, sir, do you think you can sit here today and fairly and impartially rule on the facts and the evidence that's presented to this body that involves Mr. Burns' license?
Yes.
No further question.
No question. Okay.
Mr. Bordelon, your excuse, you can step down. Okay. Did you want to make a final?
I have no further testimony on the subject. Just
Mr. Banks, anything further?
He says he can clearly, he inquired as to his attorney what he could and couldn't do. He got the answer, and he indicates that he can impartially hear the evidence that may be presented.
Okay, I'm going to deny the motion for accusal. The witness has testified that he's able to be impartial and unbiased. Next item is the motion to strike.
Yes, sir. And this involves the accumulation, I believe the accumulation of causes of action or causes against Mr. Burns. Counsel for the board sent a letter to Mr. Burns in compliance with the Administrative Procedures Act, specifically Section 961, back in May 23rd of this year, which is attached as Exhibit 1 to our motion, which included the complaint filed by New Orleans Auction Gallery and the summary, I guess, for lack of a better term, that I believe Mr. Peck prepared. And the notice provided Mr. Burns with knowledge at that point that the complaint had been filed against him. Since that time, the notice of hearing in this matter refers to issues related to an employment agreement with Sandy Edmonds and various issues out of that, arising out of that, and subsequently a amended notice of hearing was filed. I don't know when. Mr. Burns received it on or about the 1st of September, I believe, that refers to allegations concerning Ms. Dow and whether her serving as counsel and prosecutor raises a conflict somehow associated with Mr. Burns. I don't know. But Mr. Burns has not received any notice under 961 concerning anything to do with Ms. Edmonds or anything to do with Ms. Dow before the notice of hearing or the admitted notice of hearing being filed, and I think under 961 because his license may be suspended, rescinded, or revoked. he is entitled to an opportunity to respond to that, whether he chooses to or not. And the New Orleans Auction Gallery's complaint, we understand we're going forward on that. But I would object going forward on anything other than the New Orleans Auction Gallery complaint.
There are two, there's an original complaint, and then there is an amended complaint. This is I've already marked my exhibits, so this is kind of out of order, but let me provide to and ask that this be provided to the hearing officer. This is a copy of a letter that was sent to Mr. Burns on July 20th, 2012, in which he acknowledged receipt on this on July 24th, 2012, in which he was told in the letter that he continues to raise issues concerning the employment agreement of Sandy Edmonds, and reference to his continuing reference to this as blatant payroll fraud, and that in that particular letter, I indicated that I referred this matter to the board chairman to determine if comments should be added to the hearing on September 17th. And in the interim, in accordance with the requirements of the law, you should consider purging yourself of this false and misleading statements by informing this office of your error. That was acknowledged and received by Mr. Burns on July 24th. We have had no response from that filing, and as a result of it, the hearing order was amended to include this specific allegation. I believe that's in full compliance with giving him the opportunity to comply with the law by purging himself of the false and misleading information, and his failure to do such is allowed us to move forward with the amended complaint.
The amendment pertains to conduct and statements regarding Ms. Dow, not Ms. Edmonds. The board's original complaint included the information on Ms. Edmonds, not the amendment.
I don't have 961 in front of me. What type of note, how is the notice, in your motion, there's an attachment, Exhibit 3, the amended notice of hearing. How is this deficient?
961C states, no revocation, suspension, annulment, or withdrawal of any license is lawful unless, prior to the institution of agency proceedings, the agency gives notice by mail to the licensee of facts or conduct which warrant the intended action, and the licensee is given an opportunity to show compliance with all lawful requirements for the retention of the license. And continues, but that's basically the language at issue.
So you're saying he should have gotten notice, then an opportunity to cure any alleged defect before the hearing, or is it notice and then come to the hearing to present your argument?
No, according to this, before they go to even noticing a hearing, they've got to give him the opportunity to show that he complies, which they did with the New Orleans Auction Gallery, excuse me.
On this amended notice of hearing, do we have any documentation showing that this was transmitted to Mr.
On the amended,
Yes.
the amended was, which has been marked as exhibit number 6.
Okay, I'm looking at an August 27th letter addressed to Mr. Burns, closing the amended notice of hearing. Has a completed return receipt dated 9/1/12. This Have you seen this, Mr.?
I haven't seen the full document. I saw the first page, which is the relevant material, which is what I attached, which alleged the amended notice of hearing to come on the first page, which asserts the facts.
Well, my understanding of 49-961 is that before any type of action can be taken, the respondent or the licensee must be given notice of what the intended action is and what the complaint is, and given an opportunity to respond. From what I'm looking here, he received notice of the intended action. Here's his opportunity to respond.
If that were the case, sir, then the 961 notice and a notice of hearing would be one and the same thing, which they're not.
I'm going to deny the motion to strike. Again, just for the record, I'm denying the motion to strike based on my understanding that Mr. Burns was given notice of the allegations with respect to the New Orleans auctions gallery, the issue with Ms. Edmonds, and the issue with Ms. Dow. Any other motions by the party?
No, sir.
I'd like to ask, I'd like to name my witnesses, and I'd like to ask for sequestration in the event that we're going to have any witnesses by the opposing counsel. Mr. Lowry, Mr. Burns, I'd like to call on cross-examination, and I'd like to call Ms. Dow.
What's Mr. Lowry's first name?
Patrick.
It's Anna Dow.
Yes.
Mr. Parker, do you object to any sequestration?
No, no.
Mr. Patrick Lowry. Patrick Lowry, can you come forward, please? And Ms. Anna Dow.
I'm sorry.
What we're going to do, we're going to have you step outside. Basically, we're going to discuss any of these issues with you. As you come in, you have to testify. It's already recorded. Thank you. Let me see if I set it on top of this thing over here. Mr. Burns, Ms.
I don't intend to call anybody from Mr. Burns. If a reserve like
Okay, we can start. Anybody, recording have opening statements or?
What I'd like to do, if I could, there's a number of documents that I'd like to introduce. I've already marked these. I doubt there will be any objections to them, but marked as exhibit number 1, which is the auctioneer consumer complaint form, which I'd like to offer and file as exhibit number 1 and provide copies to the board members of that.
Any objection?
Well, yes, sir. I mean, again, this is an administrative hearing and the rules of evidence are lax, but to the extent that we don't have someone from the complaining party or company here to even offer any evidence or testify other than this writing, I object, and certainly, it's probative value. It's not even a sworn affidavit or anything else. To the extent that Mr. Bankston is offering it as for its probative value, I highly object to that.
I'm not overruling the objection. Again, this is an administrative procedure, the rules of ethics.
Next, I'd like to offer and file and introduce exhibit number 2, which is a letter dated May 23rd, 2012, in which was received by Mr. Burns, which includes the notice of failure to comply with complaint, as well as a notice of failure to comply, which attached the previous document we just went over. I'd like to offer that as exhibit number 2.
To the extent that it's being offered to show that the notice was given, I certainly have no objection.
And here are some copies for the board members.
Okay, for the record, number 1 and number 2 are accepted.
The was a letter dated July 12, 2012, certified mail to Mr. Robert Burns, received on July 17th, which I'd like to mark as exhibit number 3. And copies provided to the board.
I object to the relevance of this. It's just noting that there's been no response and requesting that Mr. Burns cease from having ex parte communications or not having the ex parte communications. It's not really getting relevant to what's before this board for hearing.
It's just an acknowledgement, Your Honor, that there was no response by Mr. Burns to my request to comply.
No.
I'm sorry, Judge.
Exactly.
The next document, which I marked as exhibit number 4, is a letter dated July 20, 2012, which was received on July 24th by Mr. Burns. And this one is exhibit number 4, and here are copies for to the board members.
No objection.
The board is admitted.
The next is a letter to Mr. Burns dated August the 14th, received by Mr. Burns, certified mail August 16th, 2012. Notice of the hearing, marked as exhibit number 5.
No objection.
Next, I'd like to mark as exhibit number 6, a letter dated August 27th, 2012, addressed to Mr. Burns, which was received, indicates on received on September 1st by Mr. Burns. The letter dated August 27th, that's exhibit 6, the exhibit we previously discussed.
No objection.
And copies for the board members. And at this time, that's all of the documents that I'd like to introduce at this time.
So we have 1, 2, 3, 4, 5, and 6.
Correct.
Next, we can call you for
I'd like to call Mr. Burns for cross-examination.
Just sit up there. Sit up there.
These are kind of awkward, they go a little backwards. See. Look good?
That's good.
Mr. Burns, if you'll please raise your right hand. Do you solemnly swear the testimony about to give in this matter will be true, nothing but the truth, so help you God?
I do.
Thank you.
Mr. Burns, please give us your name and address.
Robert Edwin Burns, 4155 Edson Lane, apartment 228, Baton Rouge, 70809-2150.
And you are a licensed holder with the Louisiana Auctioneers Licensing Board.
Yes, sir.
And your company name is Auction Sells Fast, is that correct?
That is correct.
You were in here and present when we went over these various documents. Do you recall receiving these documents that we went over at the approximately the time I would go over those.
I do recall receiving each of the documents that they make reference to.
Did you prepare a response to any of the allegations, either in the original amended complaint or the complaint?
The original complaint asked for nothing. It was a series of threats, of litigation against me. No, I did not.
In reference to the allegations in this particular complaint that was provided by New Orleans Auction Galleries Incorporated, did you make these statements that are indicated in this document?
I would ask the council to point out specific statements.
Let me show you, it says additionally on November 15th, Burns, and it's with reference to a specific allegation that was supposedly made.
What exhibit is that, I'm sorry?
I think this is going to be on page 1 of the,
He's looking at Exhibit 1.
Exhibit 1.
Which is the original complaint.
I'm sorry, you have to repeat the question, Counsel.
did you make any false statements about New Orleans Auction Gallery?
I made one statement that was technically inaccurate. One. I'm happy to specify what that is, and it goes to the quotation that you're making here.
And what was that?
That one statement that I made that was technically inaccurate was when I said that the previous day, the federal bankruptcy court had denied the motion to disband the unsecured creditors committee. And I have the actual filing from the PACER system from the bankruptcy court. What actually was denied was the motion for the expedited hearing to hear the matter of disbanding the unsecured creditors committee. That was a technical error on my part as a result of having read numerous documents. That is the only technical error I made. I certainly, well, first of all, I didn't make any testimony, period. It's not on the road. But other than that, no.
So in reference to this comment that you made about the unsecured creditors and the dismissal of the disbanding of the committee, did you later correct that on your website?
Yes.
And when did you do that?
At the point that late March, when, I believe it was March 23rd, and I can get, Mr. Peck references the date at which it was actually, April 3rd, I'm sorry, April 3rd.
And
It was actually denied.
my question was, did you in fact correct your error on your website?
I never made it. You talked about what we said here. Are you saying that I said on my website that motion had been denied?
Mr. Burns, you need to answer my question.
I'm trying to.
Did you said something in error, correct? Or you wrote something in error?
No, I did not. What I said was, at that November 15th meeting, which is the highlighted text that you have, counsel, yes, I made one technical error. It's pretty immaterial, but yes, my statement that the unsecured creditors committee, that the motion that Mr. Stewart Peck made the day before had been denied was incorrect. It was the motion for an expedited hearing that was denied.
So there was no attempt to disband the creditors committee?
Yes, there was an attempt. He filed a motion.
And it didn't happen, though. You indicated that it did, in fact, happen.
I didn't say the creditors committee was disbanded. That's completely false.
Let me show you, and I'll mark this as exhibit number 7 and ask for you to examine this document, which is a letter addressed to you and to Mr. Phillips, dated April the 3rd, 2012. Do you have a copy of it?
Wait, do you have that letter?
Are you intending to offer that this
Yes,
time?
ma'am.
I would object.
So he has to show him the letter and see if he can identify it. Mr. Burns, you should have access to those documents at your point.
You ready? Are you familiar with this letter dated April 3rd, 2012?
Yes,
Indicated in a letter that you made a false statement before the auction board regarding the debtor. And then reading from the first full paragraph, second full
Your
paragraph.
Honor, if I may interrupt, we're now going beyond the complaint that was filed in here. We've got Mr. Mr. Peck, Ludengool Firm's letter that he's attempting to cross-examine this man on a fact that is not even correct by the first document that he used. The attachment to the complaint states that the motion to disband had been filed, and that was the question that Mr. Bankston asked this witness immediately prior to going to this document.
Your objection is as to relevance.
Well, relevance, and, you know, I know you can let hearsay in, but this is well beyond the realm of something pertaining to the complaint itself. We have the complaint in the evidence. And now we're going to a letter that was written outside of anything that we're doing with this board, and Mr. Bankston's attempting to use that to somehow cross-examine this man about a fact that's in the complaint that's filed in the evidence.
Well, Your Honor, in reference to the statement that he had, the statement that's referenced here is further amplified in a letter he was warned even previously about making this false statement. And in this particular instance, this is just a further letter to him about that specific issue that was sent to him before the complaint was filed.
The question the counsel asked was it his position that a motion to disband was not filed? And it was, and it's clearly established here. I think Ms. Jacobs has a question.
Your Honor, I would like to be furnished with a copy of LALBff 37:3121A. And I'd like the other board members to have a copy of it, since this is what Mr. Burns is accused of violating, and I would like to see if this particular hearing meets all the requirements in that. I mean, I think that's important.
Well, what we could do, we could have a short recess if you would like a copy of that.
I think I'd like every member to be furnished with a copy of it.
Okay. What we could do here, is there someone here from the staff that is able to go?
I have a copy of the statute in my vehicle. I don't have a copy of it in here.
They should have access, should have a copy.
I mean, I can ask them. They're very specific in not sharing certain things with us.
It's on the AG's
I'd like to copy of that.
If you can make a copy.
And tell me the specific
It's
statute.
Title 37, is it 3121?
3121A is the only one that I believe he's accused of violating.
Correct.
3121A?
Yeah, you can do that now. And is it okay with this? She's going to do that.
Yeah,
now.
absolutely. You can
Okay.
continue on, but I need a copy of that before I can say whether or not he's violated anything.
Right. That's understandable. Now let's get back to this letter. Your objection is based on relevance, and Mr. Bankston, I believe you're in the middle, say maybe why it is relevant.
Well, this was a letter that was a precursor to the filing of the complaint, in which they further amplified the violations that he was making and the information that he was providing that was false.
Give me a second. The allegation here is that Mr. Burns made false and defamatory statements, specifically with respect to bankruptcy action involving New Orleans auction galleries. This letter is addressed to Mr. Burns. It references inaccurate and false statements to the auctioneer's licensing board with respect to New Orleans auction galleries.
Thank you.
Did Mr. Burns indicate that he received this letter?
I did receive that.
Certainly you can ask him his response to the letter, and whether or not it's true, but I think it's relevant, and the board can put whatever weight they want on it. I think it's a relevant document.
That's why we need to see the statute. That's what he's accused of violating.
Well, I guess just to back up, as I understand it, the allegation is making false.
But what does the statute say? Are you opening it up for the discussions at this time, or are you ready for that?
Well, wait.
Because I have some comments that I want to make.
Wait a second. I think there are references to the statutes in the letter.
But I want to see exactly what it says, and if you're opening it up to comments, and I want to comment. Okay, and I'll keep my mouth shut. Which is hard for me to do.
Mr. Burns, it says in your November 15th comment, last night they filed and a judge denied that motion. You're referring to the disbanding of the committee?
That is correct, and I told you that was the one technical error that I made, and I admit to that.
And when did you admit to that?
Meaning,
Today, I know you admit to it, but prior to that, when did you make that correction?
everything I have done, Mr. Bankston, I have done in consultation with the council, so I can't give you the exact date that I made that admission to him.
Well, the issue is, did you tell the members of this board or publish in some way the error of what you produced?
That's not the issue, Your Honor. It subsequently was denied. Was he supposed to admit back in November after it's been denied? I was wrong when I said the motion was denied. It was an ex parte motion. After the motion that he's talking about was subsequently denied by the bankruptcy court. His error was when he told the board the motion was denied. It was in fact a motion for expedited hearing. He made a mistake. He's admitted it here. But the motion was ultimately denied. So was he supposed to go back and say I was wrong? No, the motion was denied. I was wrong at the time.
Well, I don't think that the question is, was he supposed to? I think the question is, did you? I think that's the question.
Did you?
Wait. Is he saying, did he advise the board that it was a mistake, or did he advise Mr. Peck, who's really not relevant whether he advised him or not?
He can ask the question, did you do something? Whether or not he was supposed to do something, I think that's an argument that jury can make. But
Fair enough.
He can ask him, did he do something?
Did you
Did he what?
advise anybody that you made this error?
Yes, my counsel, after I got the letter, when you have the letter in front of you, that prompted me to go back. I have it on a CD right there. At the time, every filing made with New Orleans Auction Gallery. There's now, as of about a week ago, 506. So I think I did pretty good to make one small error. But yes, now, and I don't see the technical relevance of it in any regard. Attempted to disband the creditors committee.
Mr. Burns,
Mr. Peck.
Mr. Burns, you're not answering my question. You're certainly willing to allow to explain your answer. But once you receive the complaint that was filed in this particular case and pointed out the error as it relates to that
Your
complaint.
Honor, this should be addressed to you. You should not be arguing with the witness.
Once you receive the complaint, it gives you an opportunity in the complaint process to purge yourself of the error. Did you do that?
I wasn't aware I had made the error.
even though you read the complaint?
That is correct. I had to dig through 506 documents to find out what the nature of my error was.
Did you have any grudge against New Orleans Galleries?
Absolutely not.
You were involving yourself in the aspects of trying to, I guess the best way to kind of put it is that dissemination of stuff involving the bankruptcy, trying to affect the bankruptcy.
I made no attempt to affect the bankruptcy. My involvement with New Orleans Auction Gallery is no different than my involvement with numerous other auctioneer licensees that have appeared before this board or had problems or didn't conform to auctioneering standards, which escrowing the funds is one.
On your website, did you attempt to disseminate information concerning the bankruptcy and whether or not the bankruptcy should go forward in certain aspects?
Whoa. It has nothing to do with testimony before the board. The complaint and the information that counsel has thus far introduced concern his relatively inaccurate statement about the dismissal. Whatever he's put on his website, it's not not testimony before this board, has nothing to do with these proceedings.
Well, Your Honor, the allegation in the complaint indicates, and I'll read that portion that says, that at the time Mr. Burns made statements regarding the motion to disband the Committee for Unsecured Creditors, the motion to disband was pending before the bankruptcy court and had not been ruled upon. What he was saying was false. To say that the motion to disband the creditors had been denied. It also indicates that he was taking positions that were attempts to, in effect, mislead concerning the debtor's finances and the recoveries available to the creditors.
And what's your question? Can you repeat the question?
Well, the question was, do you deny the allegations within this complaint?
Absolutely, and in reference material from my website, I would appreciate you leaving it off to.
Did you in fact disseminate documents which were intended to inhibit the ability of New Orleans auction galleries to reorganize under the bankruptcy?
Absolutely not.
You didn't do that?
Absolutely not.
Did you in any way solicit authorization or rejection of the bankruptcy plan? Suggest that?
Absolutely.
You know, what does that have to do with this hearing?
Yeah,
Absolutely not. Okay, I'm sorry.
yeah, I think we need to focus a little bit on the false statement aspect.
Once you received this letter, which is marked as exhibit number 7 on April the 3rd, did you respond in any way to the allegations in this letter?
Submitted the material to my attorney, and I have followed the advice of my attorney from the day that letter arrived until today.
Did you give anything back in reference to the complaint as it relates to this letter in any way?
To the extent he is asking for privileged communication from counsel, I would object and direct my client not to answer anything that would have to do with confidential communications.
You can answer without giving any type of confidential information answer.
I have forgotten what this question was.
Did you respond to anything related to this letter as it relates to providing information to the board?
I responded to no one.
Other than your attorney?
I don't recall the letter asking for a response. In fact, I have it in front of me.
Mr. Burns, under the amended complaint, you have continued to raise the issue as to whether or not the general counsel and the prosecutor raises a conflict. Is that correct?
That is correct.
And you have continued to do this on your internet site, raising the issue that you believe that the attorney for the auctioneer licensing board has a conflict of interest.
It said on my website, I assume you can produce that.
I'm asking you.
It said on my website.
Mr. Burns,
No, I have not on my website.
Have you said it here at the board meetings?
Have I? No.
You've never said that you believe that the action of the prosecutor as well as counsel for the board,
Way back in September of 2008, which was my very first board meeting, I did not raise the issue with the board. I addressed the issue privately with Ms. Dow. I sought an Attorney General's opinion, and as you have seen, they issued that, and I supplied the members of the board on a matter of public issue with that. It was mine. I mean, I didn't even have it, and I'm not giving it to them.
so after you received the Attorney General's opinion, you did not continue to raise the issue of the conflict of interest that Ms. Dow had as prosecutor as well as board?
Yes, I did.
You did continue.
I did continue, and it's a matter of public interest. That letter from the Attorney General's office is fraught with litigation, appeals cases that have been as a result of that very setup. I made the suggestion that the board consider that. It was said, my suggestion, I assume the board members still have the email, I do. I said, my suggestion for what it's worth is the board consider this. That's it. It's a matter of public interest. Certainly, I believe, I have the right in the First Amendment to express my own opinion for what it's worth. And that was the wording I used in the email, Mr. Banks.
Have you expressed in your opinion to the board members as well, or on your, have you expressed on your website at any time after you received the Attorney General's opinion that you believe that Ms. Dow was had a conflict of interest and should not be operating even though you had the Attorney General's opinion?
Never has that been placed on my website.
And have you sent emails to board members on that very issue?
I just told you that I said my suggestion for what it's worth based on this Attorney General's letter and the litigation that has arisen from it, from the Board of Dentistry, the Board of Chiropractors, the Board of Ethics, that I think it's a practice to, not personally, the first time I saw it, where the attorney was serving as general counsel and prosecutor, I didn't like the setup. I still don't. That's my right to have that opinion. And I'm very strong about it. Now, I made the suggestion, they're free to ignore the suggestion, but to suggest, to infer that I have no right to even bring this issue up, quite frankly, counsel is astounding to me.
Let's look at that email that you referred to. Do you recall what you said in that email?
I said my suggestion for what it's worth is that you separate the two phones.
I think we're on number 8. Is that correct? Now, this is an email that you sent on July 12th. Is that correct?
Wow, man. These are what, should I be quiet?
In reference to, is this one of the emails in which you continued to object to the role of Ms. Dowd, even though there was an Attorney General's opinion on this?
The Attorney General's opinion, I assume you have read it, Mr. Bankston, and it's also not an opinion. It was just a letter. It was not a formal opinion. It stated that that practice in and of itself is not a conflict. There were other criteria that would have to be met to permit the situation. My point, and I think I have clearly referenced in here, Board of Dentistry, Chiropractic Board, Board of Ethics, entailing the same attorney serving as both general counsel and prosecuting attorney. And I said, recall, I sent each of you the letter I received from the AG's office on that issue when I was a board member. I'm assuming you don't have that email. That's the one where it said it would be my suggestion for what it's worth.
I do have a copy of the Attorney General's opinion. Mr. Burns, in reference to that, you continue to raise an issue about Ms. Dow's conflict of interest, even though you see a opinion that says there's no conflict.
That's just argumentative, Your Honor.
Is that correct?
He can raise that issue when he's addressing his board. That's,
I think that's, I'll let this question go. You can answer.
I have, as I have said, I guess now for the third or fourth time, this is my opinion. I don't like the setup. While it may be permissible, I think it's going to be difficult for you to deny all these cases came from the Attorney General's Office, the Board of Dentistry, the Chiropractic Board of Ethics, the Chiropractic Board and the Board of Ethics. I think it's an open invitation for appeals, quite frankly. So yes, I believe that this board would save money in segregating the two functions. That's my opinion. I've had other opinions about what the board would save money on. Some have been heard. I mean, some have been semi-accepted, and some have been blatantly ignored.
Now, let me ask you in reference to Ms. Edmonds and the issue of her employment. You were of the belief that she is involved with blatant payroll fraud, is that correct?
Those were not my words.
But you continue to post items on your website.
Ms. Banks, I think it's about the fifth time you've referenced my website. Can you produce a single hard copy printed out page from my website where I reference blatant payroll fraud?
Well,
And the answer's no.
so you don't ever put it on your website.
I have not put blatant payroll fraud on my website.
Now, you actually sued Ms. Edmonds, correct?
That is correct.
Let me show you a memorandum that was filed in reference to the lawsuit in which, that lawsuit's been dismissed, correct?
That lawsuit has been dismissed.
Let me,
It was,
go ahead.
the lawsuit certainly didn't entail payroll fraud.
Well, that's the interesting thing about it, Mr. Burns. This is I want to say, 51-page memorandum
Yes, sir.
in which it was involving the issue of an exception of no right of action and a special motion to strike. He made a number of allegations of Ms. Edmonds on an issue involving, as I recall, malicious prosecution. Was that it?
That was the initial, yes.
Okay. Let me ask you, Mr. Burns, to
I don't have it.
turn to page 7 of this document. Now, you say that you don't ever say this, blatant payroll fraud. All you're saying is you're repeating from somebody else?
That's exactly what I said.
Okay. So these references, for example, in exhibit number 8, the reference to, one second here. This exhibit number 8, in which you sent on July 12, 2012, to 3 of the board members, in which you said that your group, LALB, has advised each of you in emails soon after 5/21/12 that the Chief of Civil Service Accountability, Patrick Lowry, has indicated that the Louisiana Auctioneer Licensing Board work arrangement constitutes blatant payroll fraud.
That's exactly what I said.
And in this,
And I'll point out, as you said, that was an email correspondence with 3 board members. You use the word internet, website. Yes, that is an email I sent out, absolutely.
and then in this memorandum that you.
okay, I want to object to this memorandum.
Okay.
You know, there's a limited privilege that extends to things that are filed in pleadings when you're making good faith arguments. And that pertains to this memorandum, although it was improper person. And I would like to know, and I think this board ought to, you need to make a ruling on what provision of the statute the allegations and questions that council is going into have to do with anything that's before this board.
Let's back up, exhibit 8.
Your Honor, may I say something? Anything?
Not at this point.
Okay, well,
I'll let you talk.
on a point of order though, anything you say in pleadings, as you know, you have immunity for. You have immunity. anytime somebody files a pleading, they have immunity under the case of LALB versus O'Bannon, which is my case, United States Supreme Court case that went up to the United States Supreme Court. And I'll give you the details if you want. I don't see how you can hold anybody responsible on anything they could have pleaded. So look at the case. Go pull it. It's a leading case in Louisiana.
I have absolutely no knowledge of that.
Well, it's involving me personally and a lady named Sula O'Bannon from Baton Rouge. We made the law in 1983, and it's still the law now. It's not been changed. I think it's bad law, but it is the law.
Let's back up. Exhibit 8, which is the email. Are you going to offer?
Offer to introduce.
Okay. Any objections to Exhibit 8? I don't think
The
they have.
email?
Yeah.
No.
Okay, that'll be Exhibit 8. Exhibit 9, which is the memorandum that was filed here in the 19th JDC. You've asked Mr. Burns a couple of questions about this. Are you going to, I don't think it's been offered.
Offered.
Are you objecting to the questions? Are you objecting to the admission of evidence?
Both.
Under what grounds are you objecting?
Well, I'm objecting to having any relevance or materiality to anything before this board,
Okay.
because there are 12 grounds under 373121A that this board may consider here today. And I don't know of a single one that any of this issue dealing with, and I forgot her name, Ms. Edmonds, deals with, because number one is a conviction of a felony. That doesn't apply. Number two is deceit or perjury in obtaining any certificate or license issued as gender. That doesn't apply. Number three, providing.
What are you running down?
I'm running down the specific
Okay.
statutory points that this board can consider, and this doesn't deal. Number three is providing false testimony before the board. I don't think it's going to be or has been established that this gentleman has given any testimony before the board, but at the worst case, there's been nothing presented, and I don't think there will be anything presented about statements about Ms. Edmonds before the board, and this lawsuit, notwithstanding, has nothing to do with anything before the board. Number four, efforts to deceive or defraud the public. I don't see how anything, the statements that this man made, whether it's actionable by Ms. Edmonds or not, begs the issue that defrauds the public. Incompetency or gross negligence, I don't even have to talk about that one. Rendering, submitting, subscribing, or verifying false, deceptive, misleading, or unfounded opinions or reports. That would pertain to opinions or reports pertaining to the auction business. Statements about Ms. Edmonds have nothing to do with that. 7 is refusal of another state to issue or renew a permit or a license. That has nothing to do with it. 8 is aiding or abetting somebody to, so you got to go back to the first 9. 9 would be violation of rules or regulation or rules of conduct promulgated by the board. None of those have been identified in filings in this matter, so I assume that there's no offering on behalf of the board that pertains. 10 has to do with indebtedness to a state or municipal corporation for any tax as an auctioneer. That would have nothing to do with Ms. Edmonds or statements there too. Selling good at an auction, number 11, without having first entering into a written contract, have nothing to do with any statements pertaining to Ms. Edmonds. And then number 12, failing for a period of 7 calendar days after notice is given to make good on the check, which is the return of this up. That would have nothing to do with any statements regarding Ms. Edmonds. So this entire litany of questions and issue about Ms. Edmonds, whether it was or wasn't done, has nothing to do with anything that's material before this board today.
And I think we ought to move for a directed verdict. I agree with you.
So moved.
You can explain what that is. I'd be happy to explain it.
It's not the appropriate time for that. And I don't believe that's available yet.
Well, I think it is, even at such a hearing.
I think we can limit what we're going into, Your Honor. We'll be here for hours because it has nothing to do with what's before this board.
You've made your relevancy argument. If Mr. Banks has an opportunity to respond after I feel this topic.
Rendering, submitting, subscribing, or verifying false, deceptive, or misleading or unfounded opinions or reports. It's not restricted just to, there is no case that says it's restricted to just what a person does as it relates to his official duties, but providing false and misleading information with the intent to try to create the impression that the executive director of this association has been involved with blatant payroll fraud. There's no question that that's false and misleading, with the continued attempt to provide that information, not only to by email, but also by filing an extensive document in which it's replete with language about this.
Okay. With respect to the document, I'm going to allow, this is a pleading in a district court, the document is going to come in. With respect to the questions, we're going to go question by question. You make your objections as with respect to relevancy, but the document's going to come.
Mr. Burns, do you believe that Ms. Edmonds is involved in blatant payroll fraud?
Now, what's the relevancy of that, his beliefs and his opinions?
I think it's relevant. Why do you think it's not relevant?
Because it does not pertain to any issue that this board can sanction him for, whether he believes it or not, whether he's incorrect or not. It might give rise to Ms. Edmonds having her own grounds for filing a suit for defamation, but has nothing to do with what's before this board.
I think it's relevant. You can ask the question if you can.
Based on what I was told by Mr. Patrick Lowry, and based on what I was told later that same day by Mr. Calvin Moore, which Mr. Lowry recommended we go to at the Legislative Auditor's Office. In fact, he sent me a letter dated April 1st, 2011, expressing pleasure with the fact that I had gone on to the Legislative Auditor's Office with that. Mr. Lowry also suggested I contact Channel 9. I did so. Paul Gates won't remember it now, but unfortunately, because of his diagnosis, I did so. Mr. Lowry also suggested in this three-way phone call that I have documented here on November the 8th, 2011, that I contact you on your side. It's amazing that apparently I guess he would now see no problem with all these because he did nothing, but he can also have the sworn affidavit of Ms. Sherry Wilkes that he most certainly said it was payroll fraud. I'm not qualified to make the judgment of whether or not this was payroll fraud. The entirety of the video of January 10, 2011, wherein this board approved that employment agreement, which is right here, was seen by all of these parties. And, let me strike it. Let me not strike it. Let me correct that. Do not know for a fact that Mr. Lowry watched that video. Mr. Moore certainly had, and he said that having a cell phone in your person and being on call for a job does not constitute being on the clock. Furthermore, Mr. Moore was shown.
I'd like to object. This is non-responsive to.
You asked me, and I'm sorry. You're in charge. I'm sorry.
You can finish. You can finish.
Yeah, you're the judge.
No, he said you can
I'm
finish.
allowing you to finish your answer.
Okay. You asked me what I believe. I am laying the foundation for what I suspect. I never said this is blatant payroll fraud. I'm not qualified to make that determination. I have quoted a number of people who are, in my opinion, and I rely upon them. If they gave me bad information, and as I said, Ms. Evans sent me an email dated, I think it was, I'll have to pull the folder, which she said I can't do, June 6, 2010, indicating that she was not going to be available the entire next week. None of it. All right? And she says, Ken is aware I'll be out. Yet on her payroll records, she shows that she was on the job not only for this board, but for the other board during a week-long vacation. That's what Mr. Moore said is a serious problem, Mr. Bankston. And I have those emails, I have the timesheets. So, I have some grave concerns, especially considering it's my money that is, I mean, it's the other licensees too. But my concern is with the board permitting this. And I might add, Mr. Lowry said, and I want to quote him, how could any board be so stupid as to have approved something like this? End quote.
Finished?
Yes.
Okay. Now, in reference to your comment, were you not told by Mr. Lowry that Ms. Edmonds is not a civil service employee.
And I have repeatedly said that, and that's why he refers on to the legislative auditor's office. He also said if he had the authority, he would start immediate proceedings for payroll fraud. I said I don't know how far you're going to get with Ms. Evans on payroll fraud, given that she has the blessing of the entire board.
So you think it's payroll fraud?
Mr. Bankston,
You think it's-
Mr. Bankston, you have asked that question, and I have answered it. My belief is based on experts, or so-called experts, to which I've been guided to. We didn't go in there and say, is this payroll fraud? Because, and I say we, it was me, myself, and Sherry Wilkes. Fred Phillips is not here now. He was involved in these meetings, okay? We were never at any time told not to continue collecting payroll records. We were encouraged by Mr. Moore to continue collecting payroll records. I submitted Freedom of Information Act request, and then we gathered the payroll records. The legislative auditor's office came in. I don't know whether they wanted to skirt the issue by saying she's not even entitled to accrue leave, period. That's what they did. I recognize the governor's office said, well, we're making an exemption, but we're cutting out these like employees. But all I can tell you is, from Mr. Patchflower's office to everyone that I spoke with at the legislative auditor's office, they never once said, we don't believe there's problems here, not one time.
Has anybody told you that there's payroll fraud in reference to the classification of a non-classified employee? Has anybody told you that?
Mr. Patrick Lowry did. But he said he had no authority to pursue the matter.
For a non-classified
If
employee?
he said if she was classified, he would commence immediately.
And if she was unclassified, he had no authority, and they don't.
I have never denied that. That's why he sent us on to the legislative. He also said you could go to the Inspector General's office with this, but we opted to go to the legislative auditor's office.
And did they do anything?
Did the legislative auditor's office do it? Yes, they came in here and conducted, and they said that, like I said, I'm sure you've seen that report. It clearly says she shouldn't have been accruing leave. So I don't know where, they sent me a subsequent follow-up. I do not have that email here with me, but they said we do not consider this issue dead, so that we're not going to be at liberty to divulge to you what we're going to do from here.
But you continue to refer to it in pleadings and opportunities to discuss it, continuing not to describe that Ms. Edmonds is a non-classified employee, but continuing to refer to Mr. Lowry as the person contributing this issue of blatant payroll fraud.
Mr. Bankston, the email as well as the video, and I have the video to play it back for you, said I would strongly encourage this board to modify its existing employment agreement. I have a copy of that employment agreement. If you read section D, it clearly allows her, she has every right to do it now because the board's given her permission. She has every right to go out and lay on the beach and claim she's on the clock. And so I have said, given the statements that have been made by government officials, I think it would behoove the board to modify the employment agreement. Every time I've made that suggestion, it's just fallen into, a deep well. So if the board wants to continue with that written policy, and when they face the next audit, say, where's her employment agreement? And it still says the same thing it said when James Comer signed it on January 10, 2011, and Greg Bordelon served as one of the witnesses, that's fine. They can do that. I'm just saying I don't think it's advisable.
No, you're more than saying it's not advisable. You're saying in pleadings that Ms. Edmonds deems committing blatant payroll fraud by Louisiana Civil Service Chief of Accountability, Patrick Lowry, even though you know for a fact that Mr. Lowry will tell you that they have no jurisdiction whatsoever over unclassified employees.
That's just an argument, Your Honor, that can be addressed by Mr. Bankston in his closing statements. That's not a...
You want to say?
What's the question, Mr. Bankston?
You continue to put in pleadings and on your website or on emails in which you continue to refer to Ms. Edmonds' activities as blatant payroll fraud.
That's an interact. I'm sorry.
I'm going to agree with you and sustain that objection.
Your Honor, for the completeness of the record, I'd like to introduce exhibit number 10, which is the Attorney General's opinion. Addressed to Mr. Burns on December the 16th, 2008.
Any objection?
No. No, Your Honor.
That's all the questions I have, Mr. Burns. At this time, I'd like to call Patrick Lowry, or if you want to.
If I might ask him a few questions, I may not have to call him back. I just have a couple more to ask him.
Any objection, Mr.
No.
Banks?
Mr. Burns, Mr. Bankston showed you the letter of Mr. Peck. You still have that in front of you? I believe so, yes, sir. And in that letter, is it true that Mr. Peck indicated that he might bring contempt of court proceedings in the bankruptcy court against you?
He did.
Have you ever received any contempt of court citation from the bankruptcy court?
I have not.
In that letter, Mr. Peck indicated that he reserved the right to seek monetary sanctions against you and an injunction against you to stop solicitations. Have you ever received any further letters after this April 4, 2012 letter, or pleadings wherein damages were sought by New Orleans Art Gallery or injunctive relief?
No, sir.
Other than receiving the notice of the hearings, the demand that Mr. Bankston put into the evidence and the hearings, or hearing that was scheduled in this matter, have you received any official notification or court pleadings or demands from anyone pertaining to any statements or actions you've taken pertaining to New Orleans Auction Gallery?
I'm sorry, can you repeat the very first one?
It was very long.
Yeah, I'm sorry. Usually I can follow up. That was a little too long.
You're familiar with the exhibits that Mr. Bankston introduced before we started pertaining to the letter that you got in May and the notices of these hearings?
Yes.
And you identified Mr. Peck's letter of April 4, 2012 as Exhibit 7, correct?
Yes, correct.
Other than those collective exhibits being letters, have you received any other written demand, notification, or service of legal pleadings from any court pertaining to statements that you made either before this board or elsewhere regarding New Orleans Auction Gallery?
No, sir, I have not.
That's all the questions I have at this time. Thank you.
Does anyone from the board have any questions for Mr. Burns?
I have some questions. Mr. Burns.
Yes, ma'am.
I mean, they're charging you here with a statute. You obviously have read the statute that you charged with.
Yes, ma'am.
They said that you have, it's a website, is that correct?
I have a web page. Well, there is a website, yes.
Or a web page, wherein you express your opinions?
No, ma'am. Well, let me qualify. And I have a hard copy printout of the web page, although I can even go to it online if you want. There was a recapitulation of the entirety of everything that happened in New Orleans Auction Gallery, to where anyone can go to this and in about 12 to maybe 15 minutes get up to speed. That was condensing what at that time was approximately, 380 filings that had been made in New Orleans Auction Gallery. I do find it interesting that Mr. Peck apparently found no exception. You know, I mean, this is the one technical thing that he got. And that wasn't on the website. That was a statement made to this board that was technically inaccurate. And so for that to be the only thing, I give myself an A. But yes, I had a website that was a recapitulation of the events that had taken place up to and including the day that website was disseminated out, that web page was disseminated
Did
out.
anyone move to block your website or to shut the website down?
When you find move.
Did you receive a notice from the people that operate the website that you should shut it down because of bad information?
No,
All right, you know that sometimes that does happen, and they can make you take that down.
Correct.
So I take it that in the webpage and when you express certain things, you were expressing your opinion. Your opinion as an individual, is that correct? And not as an auctioneer.
Toward the lower part, well, yes. Toward the lower part, there were opinions expressed.
Okay.
The upper part, which was 85% of the content of the webpage, was pure recapitulation.
So you were giving your opinion under the First Amendment rights as a person and not as an auctioneer, is that correct?
Yes, ma'am.
Just as anybody else is entitled to opinions that they can give regarding this country being so great that it is that we can exercise our freedom of speech, is that right?
Yes, ma'am.
Did you give your opinions based upon malice,
No, ma'am.
jealousy?
No, ma'am.
Were you attempting in giving your opinions to compete with New Orleans auctioneers?
No, ma'am, and my only interest in auction has always been real estate. As I have, every call I get that is not real estate, I tell them I have absolutely no interest.
So in other words, you were not, in giving your opinion, you were not attempting to throw scorn on New Orleans auctioneers, close them down, or actually compete with them.
That is correct.
So you're giving your opinion as an individual. As an individual and not as an auctioneer.
That is correct, and again, I want to emphasize it's only on the last bottom part, 15%. That could even remotely be construed as opinion. The rest of it is pure statements of fact. You take a pleading, you say, this happened, this happened, this happened. But the last 15%, and I want to, I mean, since you asked if I had read the allegations against me, yes, I have. I find them interesting in that I'm accused of being incompetent and grossly negligent.
You see, as I read this particular statute, if I were interpreting the statute, it would seem to me that the statute deals with obtaining an auctioneer's license, not with rendering an opinion.
Well, that would be
The
mine,
statute.
and I think my attorney will let him speak for himself, I think.
Well, he hasn't, so that's why I'm speaking up.
Oh, I thought he did.
That's the way I interpret this statute.
Well, that's certainly the way I interpret it. In fact,
Just answer the question.
my attorney said,
Are you what they call a frustrated lawyer? Do you know what that is?
well, I assume that's one that's got an axe to grind.
No, that's people that don't go to law school, but they want to be a lawyer and express opinions. Because, and I'm not saying this in a derogatory sense, but I believe you are. If you had gone to law school, probably I would be hiring you.
Well,
I like some of the briefs you write.
well, thank you.
You do a pretty good job, better than some lawyers in the state of Louisiana anyway. I don't agree with all of your opinions, though.
I understand.
Any other questions? Yes.
Well,
Ron, as you know, there's 4 people on this board. Been on here a little over a year.
yes,
A lot of this, it goes back prior to us. This New Orleans gallery, all this other stuff that's going on, when I came on the board. But I got one question, I'm just curious. And I think I deserve an answer because it's a simple question. Why is all your interest in New Orleans gallery? What made you want to? And I'm not saying you're not entitled as an individual to give public information on the family. But I've never seen an auctioneer, I've been in this profession since 1973, and I've never seen an auctioneer get so enticed from a bankruptcy proceeding in my life. And I've seen some. I've seen a probably a dozen, but I've never seen somebody get so intrigued. What is your interest in this?
Well,
What, is there a reason? Do you have grounds? The board's curious.
you have every right to be curious, Mr. Simpson. I'll be happy to answer your question. All you have to do is ask Ken Bueller if my fascination with these type of things are unique to New Orleans Auction Gallery. Mr. Bueller was at a federal trial in June of last year. Mr. Kleinpeter served as one of the defense attorneys. I attended the entirety of that 4-day trial. So, and that's not, and I can give you other instances beyond Ken Bueller that I take an active interest in. I believe actions such as what happened in some of these instances harm all of us as auctioneers. And for that reason, I'm gonna stay interested in things that go on in this business, particularly things like not escrowing funds, or if they were escrowed, payments were made out of escrow. And I would hope that you as a board member too.
I understand, that's law. I mean,
And in order to get, I wouldn't know doodly squat of what was going on in New Orleans Auction Gallery were it not for the pleadings.
I mean, was this proceeding going on when you got on the board?
New Orleans Auction Gallery?
Yeah.
No, this didn't happen until April 1st,
I don't know
2011.
when it happened.
It happened April 1st, 2011 when they filed bankruptcy. Prior to that, I had no reason to believe there were any problems at New Orleans Auction Gallery, and didn't. Obviously, that was a ill-founded belief, but I had no reason to believe there were any problems at New Orleans Auction Galleries.
You made reference to Mr. Hughes.
Yes.
I know nothing about that either, so I have no idea what you're talking about. So,
Well,
to me, that was irrelevant. I mean, that
well, you asked, well, you made it out like I had a fascination
No,
with this
no,
one.
I was
Okay.
wondering what your deep interest was. I mean, you're
Yes.
entitled to have an interest in anything, but I mean, I find it kind of odd. Most people don't have time to dig into all this.
I agree with you.
I mean, you know.
But you would not challenge my right to Debbie
I
into.
have not challenged your right, Ron. I've always been respectful to your
Yes, sir.
rights. All I'm saying is this. I'm an auctioneer, and I do other things besides auctioneering. I don't have time for getting in court procedures, which I'm sure you have your reasons. I'm sure somebody told you something, or you wouldn't go there.
No one told me anything, Mr. Sims.
I mean, your interest sure got to fight for something. I mean, you got your interest aroused from something to go digging. And I'm not, you know, and that's what the bankruptcy court's for, to make sure everybody's paid in some shape, form, or fashion. It might not be 100%, but it's gonna get paid for something. And I mean, it's been my experience, if you got a bankruptcy proceeding on, it's not advisable to go digging into it. Because you get yourself in trouble real quick with fees.
Mr. Sims, everything I looked at was a matter of public
I
record.
understand that,
Every bit of it.
I understand that.
And that's why I find it amazing that of the 85%, the recapitulation part, and a 7-minute video, I might add, which I have on the iPad, which I'm not going to even address the numerous other inaccurate statements in the text, because at this point I don't think it's necessary. You know, he says that, well, I won't, but believe me, I'm prepared to. No one's asked a question, you know. No one's asked several questions.
Well, if I were Ms. Dow, Attorney Dow, and I was Tessa Steinkamp, and you wrote these allegations about me, I would be really upset. And if you were in their place and they wrote those allegations about you, you would be upset, even though it was something that was sent in the mail and not publicized, except maybe on this so-called website that you had.
Wait,
I mean,
which-
I would be upset about it. I mean, at some point you have to come to a point in your life where you worry about the things that matter, such as people stealing from the public and not pettiness. And
Well, I'm
that's
going
what
to
you
define
already.
pettiness.
Well, to me,
let's-
some of these
let's-
allegations are, I may have sued you as an attorney. If you had wrote those allegations against me, you'd probably be in a lawsuit. But I believe in the right of someone to express their opinions, and I think that's a First Amendment right, which is probably why I'm going to vote for these charges against you to be taken. Because I think you have a right to do that under the U.S. Constitution. But I mean, you can't keep making scurrilous allegations against people, and it's really uncalled for. You have a lot, as far as I'm concerned, I think you're a very brilliant person, and I think you have a lot to contribute to the board. But making allegations and keeping something in a stare is not one of them.
Okay,
Well,
let's keep it to questions, and I think everybody will have an opportunity to make a statement and express their views and their thoughts, but let's just keep it kind of narrow here and simple questions. Mr. Burns.
Mr. Burns, it seems like when you were taken off this board by the governor, I suspect who took you off, it seems like to me you were vindictive against this board. You even harassed our office on a weekly or daily basis with our ex-secretary digging up information on Miss Edmonds, who was in the office, and then you making these charges of blatant payroll fraud and stuff like that. Well, if that's false, I believe in due process. I believe if you're innocent, there's nothing that should happen to you. But if you're making false statements about these people like that, and I think that might be why you wanted me off this panel, because you know that I can't be bullied on anything. But I'm going to vote what I think is right. Why would you get the ex-secretary involved and another board member who at one time you didn't even seem like you got along with them in meetings? And it just seems like to me you just went after Miss Edmonds, you know, and I think she does an excellent job for this board.
She does.
Mr. Burns1, I'm going to state it again. If the board chooses to go with an employment policy that permits Miss Edmonds to go and vacation at the beach, and you specifically were asked that question January 10, 2011, by Reverend Phillips. He said, so if Miss Edmonds is vacationing in Miami, Florida, and she's got her cell phone with her, do we consider her on the clock? Each one of you said you did, with the exception of Reverend Phillips. That's a matter of public policy. I have the right to say, I don't believe that's the way my licensing funds should be spent. If you don't think it's payroll fraud, stick with the employment agreement.
And there was nothing personal on your part. There was nothing personal that was driving you.
There's not, Mr. Burns1, as you probably will remember, I wasn't a very popular board member. And if you read that memo deep enough, since you said it was 51 pages, it does say, you know, they said, Governor General fired Robert Burns, and I said he most certainly did. He most certainly did. And I also put in there that I had sent an email previously to Sarah Alcott saying if the choice is between having to conform and be dictated to, as was the case in those board meetings, versus being on this board, that's not a governor for whom I would want to serve anyway. And that email was put into the exhibits from that. So my position has not changed from the day I was on this board till now. I had serious problems about things that were going on this board, particularly in concerning some travel vouchers. And so yes, I probably quite likely will be making more public records requests.
So,
and I might add, action was taken.
So I'm just saying it was personal.
Nothing is personal. As long as I own a license in this state, I have every right to expect that the funds that I'm contributing in and every other auctioneer is contributing in don't go out in terms of, you know, you probably want me to shut up, so.
I think your lawyers kept trying to tell you to do that.
For the record, the first couple meetings, I thought you were an excellent board member. You were fiscally responsible, just like I was. But then I think it took a turn, and, you know.
Well, if you reference the shield bidding, yeah, I think.
No, I'm not referencing.
Well, I think all you have to do is reference the August 2nd meeting. You were there. I have the full recording of it. You know, yeah, I think a lot of things changed from that meeting for a lot of us.
Okay, any other questions? More questions from the board?
It doesn't do any good.
I think we're ready to deliberate.
No, we're gonna take a recess, 15-minute recess.
10 minutes.
15 minutes. 3 o'clock. We'll start back up, 3 o'clock. Where are the sequestered witnesses? Where are the sequestered witnesses? The witnesses.
That's it. The only thing we have is deliberation.
Yeah, I got it. You own the road.
Yeah, I understand. I got stuff to do out there. I got 2 other witnesses.
Please go on standby. I'll start.
The statute doesn't talk to you. I'm ready to vote.
He said that we had covered.
Meeting is now back on the record.
Okay, back on the record, Mr. Bankston, your next witness?
Patrick Lowry.
Okay, Mr. Lowry, can you please, swear Mr. Lowry?
Please raise your right hand. Do you solemnly swear the testimony about to give in this matter will be the truth and nothing but the truth, so help you God?
I do.
Thank you.
Mr. Lowry, I understand that you have a loss of hearing in one ear.
This one.
Okay. Please let me or the board know if there's any difficulty.
All right.
Could you give us your name and address?
Patrick Lowry, 1759 Stafford Drive, Baton Rouge, Louisiana, 70810.
And what is your position?
I am the Division Administrator in the Department of State Civil Service Program Accountability Division.
What does that mean, accountability division?
I head the division that is in charge of investigations and audits.
Do you recall there being occasion sometime back in November of 2010 in which Mr. Burns, Robert Burns, came to see you? Do you recall that?
Yes, sir.
Do you recognize Mr. Burns?
Yes, I do.
At that meeting, did you indicate to Mr. Burns that you were of the opinion that Ms. Edmonds had committed blatant payroll fraud as a result of the activities?
That is not a correct assessment of what was discussed in that meeting. Mr. Burns came to me. He was accompanied by a lady, I cannot remember her name. We had discussion about some concerns he had about the operations of the office and the hours that the executive director was keeping. We went back and forth with that for a short time. Mr. Burns was alleging that the conduct violated the leave rules in Chapter 11 of Civil Service Rules. And we discussed it, and I pointed out to Mr. Burns that the person in question was not a classified state employee and therefore was not under our rules. He countered at some point in time and insisted that she was still under our rules, and I said, what you're essentially alleging is payroll fraud that is not under the authority of civil service. You need to talk to the Inspector General or the legislative auditor. I cannot remember the exact word, but that was the gist of what I said.
So it would be a fair statement that a representation that you had indicated after hearing the information about the activity of Ms. Edmonds, that you did not indicate an affirmative decision on your part that she was involved with blatant payroll fraud.
I had conducted no independent investigation and had no facts other than what Mr. Burns relayed to me.
That's all the questions I have.
Mr. Lowry, the woman that came in with Mr. Burns, was it Sherry Wilkes?
That sounds possible. I don't really recall.
And isn't it true in that meeting that you had with Mr. Burns, and I'll represent to you as Ms. Wilkes, that she did the vast majority of the talking as far as providing you with information and asking questions?
That I cannot remember.
In one of your answers, you said that you told them what they were alleging is payroll fraud. I'm quoting. Is that what you told them?
Well, I told him his allegations were, if you have an employee that is being paid for hours they did not work, then that's payroll fraud. But I was not concluding anything. I was simply redirecting him to the agencies he should talk to.
And you recommended to Mr. Burns and the woman that they, one of the persons they might go see would be at the legislative auditor's office?
That's correct.
Did you specifically recommend that they see Mr. Moore, Calvin Moore, or just in general?
I don't know anymore.
Okay. And I understand your answer was that you didn't do any independent investigation, but am I correct in understanding what you told them was in response to the information that they were providing to you, unverified by you, that would constitute payroll fraud, but it wasn't a civil service employee, you had no jurisdiction? Is that a fair statement? That's all the question I have. Thank you.
No further questions.
Any questions from the board?
I have a question. Can you hear me, Mr. Lowry?
Yes.
Okay. When he came to you, he came to you not necessarily to tell you something, but to seek your opinion. Is that correct?
Mr. Burns was attempting to file a complaint with the Department of State Civil Service under Chapter 11 of the Civil Service Rules.
But he wanted to seek your opinion as to whether or not this was payroll fraud before filing a complaint. Is that correct?
I don't know. Well, he was attempting to file a complaint,
And you advised him that it wasn't covered under the act, is that right?
That's correct. He was an unclassified employee, he is not covered by our rules.
So he was nothing more than an average citizen seeking to file a complaint or to seek your advice on whether or not he should. Is that right?
That is correct. I mean, he wasn't seeking my advice on whether he should. He was trying to file a complaint as any average citizen that I deal with on a day-to-day basis does. This was a very routine conversation for me.
And he didn't come to you as an auctioneer and said, I'm an auctioneer, and because it's an auctioneer, I want to file a complaint against another auctioneer.
I believe he did represent himself as an auctioneer, but I don't know, I really don't remember that.
Okay, if you don't remember it, I don't want you to guess, please, because you are under oath in this forum. So, and you gave him your opinion, and as a result of that, he accepted that particular opinion as an average citizen would. Is that correct?
He took the information that I provided to him and left.
All right. Now, how often do average citizens come to you, or people come to you with allegations to file complaints? How often do you get that?
It is infrequent at times. I mean, I may get 3 or 4 in a week. I may go 3 weeks without getting one.
And when they come to file a complaint, you're going to give them your opinion as to whether or not they have a valid complaint.
Sometimes, if it is something that is clearly under my jurisdiction, I don't really give them a jurisdiction. I just accept their complaint, log it in, and conduct an investigation.
But any citizen in Louisiana, as an average citizen, has the right to file a complaint. Is that correct?
That is correct.
All right, thank you.
Any other questions from the board? Mr. Lowry, you're excused.
Thank you, Mr. Lowry, appreciate it. Ms. Dow?
If you'll ask Ms. Down to come in.
Sure.
Thank you.
It's the general counsel.
And I'll continue to her in. Please raise your right hand. Do you solemnly swear the testimony about this matter will be the truth and nothing but the truth, so help you God?
Yes, I do.
Thank you.
Could you state your name and address?
Anna Dow, 1434 North Burnside, Suite 14, Gonzales, Louisiana, 70736.
And you are the attorney for the Louisiana Auctioneer Licensing Board?
That is correct.
And how long have you had that position?
I have been the attorney since 1999 and for a short period in the 80s.
In reference to Mr. Burns, there was a period of time when he served on the board in which he was questioning the procedures of the attorney acting as attorney and potentially prosecutor, correct?
I believe that went directly to the Attorney General's office. I was not aware of it, but I believe he did question that.
He did. You weren't aware that he was seeking that opinion?
I do not recall.
Let me show you, which has been marked as exhibit number 10. Were you aware of that opinion?
Is this the one that this is, you're asking about?
Yes.
After the fact, yes.
And how did you come to find out about the opinion after the fact?
This shows me as getting a copy through the board.
So he had done this independent as a member of the board?
As far as I know, yes.
And,
At least I was not aware of it.
indicates here that you received a copy of a letter you sent to Ms. Anna Dow November 20th, 2008. And this was a formal response. This is the formal response of the Attorney General's office, as I understand.
As far as I know.
And is the process that you are presently using, and using even before this, has that been authorized and allowed by the Attorney General's office?
Yes, I have gone over the process with regard to the statutes with our contact at the AG's office. As far back as I can remember, I don't remember the first time I did it, but I've always consulted with the AG's office.
Now, in reference to this particular procedure, did Mr. Burns continue to object to?
He has brought it up over the years, as far as I know, yes.
And in that objection, has he complained about you serving in this particular function?
Yes.
Has he done it before the board?
Yes.
Has he done it in emails?
Yes.
Has he done it on his website or on his blog, I guess?
I really don't look at his website or blog very often. He may, I don't know.
In your opinion, has he attempted to create some view that the process is somewhat tainted?
That's an inappropriate question to ask her opinion of what Mr. Burns's actions are.
She can give her impression.
Okay. But he's trying to taint the process, is my belief.
And as a result of that, in reference to the issue of the process, has he ever acknowledged the Attorney General's opinion as being given to him previously and that is authorized?
Has he ever acknowledged it to her?
To her? Yes.
I don't recall him acknowledging anything to me.
Has he acknowledged to the members of the board that there's been this Attorney General's opinion in reference to this? I mean, you've been present.
As far as statements in front of me at a board meeting, I believe that there has been, that has been brought up at board meetings in past.
Now, let me show you, which I've marked as exhibit number 9, and ask whether or not you recognize that document.
This is a pleading. I believe I did get a copy of this at some point, with regard to his lawsuit against Ms. Edmonds.
Now, that lawsuit has been dismissed, as I understand it.
That's my understanding, yes.
And in this particular lawsuit, there's continuing references to blatant payroll fraud. Have you had discussions with Mr. Burns concerning his allegation of payroll fraud?
The allegation in that document in which she wasn't counsel?
Yes, because she had knowledge of that particular document and read that document.
The only thing I can say is Mr. Burns and I did not speak because there was litigation pending, and I am represented by counsel. However, there may have been times when he brought this up at a board meeting that I made a comment to my knowledge that I was aware of the payroll fraud.
Have you reviewed the issue of the contract that Ms. Edmonds has with the board?
Yes.
Have you sought the approval of Mr. Bowen, who is the former general counsel of civil service?
Yes, exactly. Not per se, not that he reviewed the contract, it was his idea to draw up the contract.
And have you sought to see whether or not that contract is compliant with what you believe is the law in Louisiana?
I have spoken to the Attorney General's office about it to make sure it was compliant, yes.
And you believe that that contract, in fact, has been compliant?
Yes.
And if you read these pleadings, and you've been looking at these particular pleadings, there is continuing reference to the words blatant payroll fraud. In those discussions, has he ever made representations before the board?
What discussion? She's testified that she doesn't speak to Mr. Burns because she's represented by counsel, and it would only be something that came before the board. And I would propose another objection. Haven't we beat this horse enough? I mean,
I'll withdraw the question. You attend the board meetings?
Yes.
And has there been discussions about this blatant payroll fraud continued raised by Mr. Burns?
Yes.
That's all the questions I have.
I have no questions for this witness.
Does the board have any
I
questions?
have some questions. Ms. Dow, would you agree that Mr. Burns is a nuisance making allegations against you, Ms. Edmonds, and Ms. Steinkamp?
Nuisance may not be the word I use, but obviously there's some issues with regard to his numerous lawsuits, complaints, comments being made against the Burns.
And can you cite me any cases in the state of Louisiana in which an attorney has prevailed on being liable because of allegations in the letter that a layperson would say against him? Can you cite me any case at all?
Not offhand, no. But
Do you know of any?
Right now, I don't do libel work, so I'm not familiar with that. I don't know if we any reason or not.
Well, there are none. Let me tell you that. All right, that's all.
Any other questions from the board? Follow-up question? Sure.
As you understand it, under the rules of, or under the statutory authority of the board, do they have actions to take against a licensee if they believe that he's been making false or incorrect statements?
Yes.
That's all the questions I have.
I'll follow up from that. What are you relying upon in your last answer? Can you cite us the provision of the statute?
Yes, Title 37, I think it's 1221, which is a portion of that that talks about making false testimony.
And don't you understand that testimony is being sworn under oath and providing a sworn statement to the board?
I do not know that.
Would you use it in its other versions, somebody giving their testimony about their Christian religious experience?
Well, yeah, testifying, yes, as to your personal Christian experience.
But other than that, testimony refers to giving a statement to a board or court under oath, correct?
Not to my knowledge.
Not to your knowledge?
Yeah. I would refer to that as sworn testimony as opposed to fixed testimony. And usually that's how.
Are you referring to any other provision in the answer you gave Mr. Bankson to the last question?
Just those two.
Two. I thought there was one,
That
providing
was
testimony.
deceit.
And it's your understanding as general counsel for, is that the title
Yes.
for the board from 1999 for some period in the 80s, that the provisions of Title 37, 2121, the causes for non-issuance, et cetera, of a license pertain to any acts, regardless of whether they have to do with defrauding the public or giving testimony concerning their practice as an auctioneer?
I'm not sure I understand the question.
Well, isn't it your understanding that the provisions of 37, 31, 21 pertain to acts or actions of a licensee that have to do with his or her job as an auctioneer?
And getting a license, they do the first one. Interrupted, but that's correct.
But once you have a license, the fact that you may lie to your spouse has nothing to do with renewing your license, correct?
There's a requirement as to good moral character also in another section of the statute.
So there's some other provisions besides 3121 that would apply to this
I mean, all of
situation?
the statute applies, obviously. There is a reference to good moral character if you read that together with the provisions of our licensing statute, including 3121. Then you could basically construe that together to interpret it to mean more than just practice.
So whether we take the good moral character out of it and we look strictly at 3121 subsection A or subparagraph A, the grocery list or itemized list in that section pertains to acts or actions involved with the particular auctioneer's license, correct? Deceiving the public, defrauding the public in connection with your license. Being grossly negligent in connection with your license, not running a red light and hitting somebody on the streets.
And being a victim of felony is also in there. I would have to go through this to be more explicit. But if you take out the good moral character requirement, there may be some issues that say this is all I have to do with practice. We have looked at other things, and the interpretation of the statute is not hard, but it's up to the board to interpret the statute.
No further questions.
I have one question born out of your questions, if I might. I recently saw on television where a man was campaigning for office and he said that he actually experienced active combat while in the Marines. Do you remember that case?
Yes.
And a lawsuit was...
There's a recent ruling on that.
Right, there was a lawsuit filed against him. The judge says he could say anything he wanted under free speech, even though he didn't see active combat.
As long as he didn't commit any harm or receive, now starting to redo that, say you can receive something of benefit as a result of
Well, but they say it was free speech, and it can say, he can do anything he wanted, he can say he won all the battles. Right?
Right, as long as it wasn't, deception.
Well, as long as it didn't infringe upon the rights of someone else and jeopardize them in their career, that's what I thought.
Yeah, I think that's basically.
Any other questions? You're excused,
Oh,
No further.
no further questions. Mr.
We have nothing to offer in response at this point.
Okay. What we'll have, does council want to present any type of closing?
I would like, yes, I would like to say something before it goes to executive session. Two things. One, learned counsel is correct on the issue of libel and on the criminal actions involving the recent Supreme Court case involving someone who was said he was a Medal of Honor member, and they tried to charge him with a criminal. But that's not what we have here today. This is a licensing board. And in this particular case, this licensing board can take into consideration what I believe has been an absolute vendetta against the chairman of the board, as well as Ms. Edmonds and Ms. Dow. And for Mr. Burns to come before you and talk about the amount of time that he has spent on this, to say that he does not have some vendetta is just, it's really laughable. There's been such an incredible amount of effort put to try to do damage to these people. He can do all he wants to try to stand behind the fact that Patrick Lowry told me this, and that therefore I can say it. All you have to do is read that document, and it's absolutely positive where he's trying to put such an incredible taint on the executive director of this board. And as a result of that, I think he has attempted purposely to give false and misleading testimony, as well as unsworn, but to stand before this board and say certain things, file emails, file a 51-page document that was involving the issue not of Ms. Edmonds' employment, but involving the issue of malicious prosecution, where he filed a 51-page document, which is nothing about anything but her employment issues. So there's, in every opportunity he has had, he has given himself the opportunity to try to slam people. And today he has tried to hide behind Mr. Lowry. Mr. Lowry clearly testified that he didn't tell him this was blatant payroll fraud. So for that reason, I think the board should consider taking action.
Mr. Quanke?
I would direct your attention to the consumer complaint form that was filed as Exhibit 1 in the comments. I assume they're Mr. Peck's comments because he signed the form. And the only thing that Mr. Peck pointed out in the filing that was allegedly an inaccurate statement was, as Mr. Burns admitted, the fact that he said that the motion to disband the Unsecured Creditors Committee had been dismissed, when in fact it was the motion for expedited hearing on that, but subsequently the motion was dismissed. You know, substantively, it turned out to be right later. He made an error. He said he was technically wrong. He's not a lawyer, and as Ms. Jacobs pointed out, you know, he's, I think, acts as a frustrated lawyer sometimes, and that's when we get ourselves in trouble, when we go outside the realm of what we do for a living, all of us. The other thing Mr. Peck said, that New Orleans Auction Gallery does not take a position on whether Burns knowingly made false statements or whether his false statements were simply as a result of his inability to understand the documents he was reading and reporting to the auction board. And that's exactly what it was. And that's why Stewart, who was a good attorney, was very careful about saying that he understood that Mr. Burns wasn't trained to go look at bankruptcy documents and understand the technicalities of what was being done. Mr. Sims asked a question, you know, why do you do this? I've asked Robert that same question. Maybe he's got too much idle time and he digs too much. I can tell you the first time he came to see at my office, he knew every administrative proceeding I had ever been in and could quote them. And, you know, at first I was a little shocked, and I said, you know, the guy's got a pretty damn good memory to be able to remember all that, like he pulled these dates up when he's testifying. That's what he does. It may irritate some people, but, you know, irritating somebody doesn't mean that you don't have the right to say it. It doesn't mean that you don't have the right to be genuinely concerned about it. You can be wrong, but you have the right to say it. You know, the First Amendment was put there as number 1 in the list for a reason. We live in a country where we defend and protect people's rights to state their opinion as long as they're not malicious and intentionally defame people. Now, if he is wrong and he intentionally defames Ms. Edmonds or anybody else, they certainly have a private civil right to bring an action against Mr. Burns, and would have every right to do so, and he would be wrong if he was malicious. But that's not this board asserting through the license process somebody's independent civil right for a defamation to redress a wrong. Mr. Lowry indicated that when he listened to the statements that were told him by Ms. Wilkes, we believe Ms. Wilkes and Mr. Burns, that he said, you know, the facts that you're alleging is payroll fraud. Now, maybe they took that and ran with it. Maybe, and I'm sure what he was telling was like, it's not my jurisdiction. I can't do anything about it. You need to go down the street. And they went down the street, and it was investigated, like Mr. Burns talked about. Again, he's entitled to his opinion. He's entitled to defer or disagree with the Attorney General that blesses something. You know, Attorney Generals have been wrong. They issue opinions just like other lawyers do, and sometimes we're all wrong. And even if it's right, you don't have to agree with it. You can lobby certainly your board that governs you, or your representatives, to change something. He's just exercising his rights as a citizen, as a licensed auctioneer. You don't have to agree with it. It may irritate you a time or two, but you got to recognize that it's his right to do so. And I would tell you there really is no basis to do anything here pertaining to Mr. Burns's license. Maybe he would be better advised not to spend so much time digging things up, but it's not just with the license. This board, he likes to look at things and accumulate information and be some, you know, like a government watchdog, like some of the people in our media. Doesn't appeal to me, but it appeals to him. And I would ask you to dismiss this complaint, and let's go down the road. Thank you.
Mr. Bankston? I think I need a motion to go into second. All those in favor? Any opposed? Okay, we're in.
To that, I think that he has the right for it to be heard in an open session if he wants to.
Well, he has the right, they have a right to go into executive session to discuss character, and other type of issues. He has the right to have those issues outside of that realm to be heard in open session. So we're going to go into executive session to discuss character issues. Once we come out of the executive session, we'll be able to discuss other issues outside of that. Also, before we adjourn, housekeeping, your motion that you filed earlier, did you give a copy to the court? Did you want to file that into the record?
Yes, I do. I was going to ask you that earlier. I will provide copies of both to the board.
Okay.
Also, before everybody else gets out of here, I can get all the other exhibits for you.
Okay. All right, we're in
We're going to turn everything off.
executive session.
I would like you.
Whoa. Chairman takes motion to come out of executive session.
Is that video ready? I'm sorry.
I'm sorry about the confusion earlier. I thought we were done. That's why I was trying to.
You ready? Chair will entertain a motion to come out of executive session.
I'll second.
All those in favor say aye. Aye. Ayes have it. Turn the gavel back over to the judge and recognize Ms. Darlene Jacobs.
Thank you, Ron. Robert, I would like you to stand up there and have a few words to say to you. And I hope your mom is listening very good because she's a good woman and I'm giving you some good advice. Okay, as an older woman, I'm giving you some good advice. I think you are a very intelligent man, first of all. In fact, I told your mother, I thought you ought to go to law school. If you became a lawyer, probably I would hire you because you have a lot of opinions and good opinions. But when you verbally harass and abuse 3 of our employees, Ms. Steinkamp, Ms. Edmonds, and Ms. Dow, I think these allegations are scurrilous and uncalled for. Probably, if I had been any one of them, I would have filed a lawsuit against you for libel and slander because these are allegations that you can't prove. Fortunately for you, I think the First Amendment protects you, particularly with regard to LRSA, Louisiana Revised Statute 3121A. And I think that you have a right to express an opinion. But if opinions are unfounded, that undermines the Constitution of the United States and free speech. And I am a firm advocate of free speech. I have fought for free speech. I've represented people who have expressed free speech. And I actually contribute to the American Civil Liberties Union to promote free speech. You understand what I'm telling you here? So you have really, there are some of us that were in favor of taking your license. I'm not one of them. And we're going to pre-admit that issue and give you another chance, but we want you to cooperate with the board and only bring up those things before this board that are germane to auctioneers with regard to things that they do as auctioneers. Not to downgrade the attorney of this bar or downgrade Ms. Dow or Ms. Steinkamp, who is on our board as chairman and giving up her time, and also Ms. Edmonds. We just think that, that kind of conduct is uncalled for. I think you have better things to do than just wrap your whole life around going into certain things on this board that are not your name. And I would hope to see better things from you. I mean, I really put my reputation on the line to fight for you in this hearing to save your license because I think you can do better things, and I would want you to do that. Because I'm sticking my neck out with the other board members here. And I hope that you will listen to my words and heed them. Because you may not be so lucky the next time. I don't need a response. I'm just giving you my opinion. And I hope, you have good ideas, and I frankly want to hear your ideas. And I think that you can contribute to society in a better way than the way that you're going about it. I just think that you have great talents, and I think you're wasting them on the pettiness that you're doing right now, particularly against these 3 ladies that are trying to do their best and earn a living or do the best for society. As Ms. Steinkamp is, she's a volunteer. She doesn't have to be on this board. It takes time out of her profession to be here. So I want to see better things from you. I expect. Don't let me down. Because if you do, I'm going to remember it. Right, Mom? Mom's shaking her head yes. That's all I have to say.
On behalf of the chair, Robert, this is our public reprimand, and that's all it's going to be. No fines, no revocation of license.
So noted.
Let's, is there a motion for the public reprimand?
Oh, yeah.
I second.
Second. Okay. All those in favor? Aye. Any opposed? No. No? Okay. I think at this point, I'll turn the meeting back over to the chairman for purposes of adjournment.
Chair, I entertain a motion to adjourn. All those in favor say aye.
Aye.
Thank you.